Hi, I'm Warren Norrid and I practice law in downtown Arlington, Texas, and this is the first in a series of videos discussing bankruptcy. And this information is designed to supplement services to my clients, so if you're watching this, you're not my client, this is not legal advice to you, and should be taken only as general information. Feel free to call us, set up an appointment, and become one of our clients. Now, when I visit with folks about difficult financial situations, I often need to describe what the process of bankruptcy entails. In fact, federal law requires that a visit to a bankruptcy attorney must include this explanation, along with some details about each kind of possible bankruptcy filings. In fact, I have to sign a document that says I gave you all this advice. It's called a 342B notice. It's rather dry, but it's important information if you're actually going to consider filing bankruptcy. Now let's begin with the general concept of bankruptcy. Way back in the beginning of time, in early human society, we learned that people occasionally get over their heads, sometimes to events outside their control, sometimes just plain bad mistakes. In either case, our society has allowed for some sort of bankruptcy process ever since the Old Testament days, and this is one of the few processes actually discussed in the United States Constitution. The goal of bankruptcy is to provide a fresh start, a recalibration, if you will, erasing or reorganizing debt so a person can go forward without the heavy burden of too much accumulated debt that is otherwise paralyzing. The bankruptcy process is one that allows creative minds to get a fresh start and go on to be great assets to our economy. The most famous person who ever filed bankruptcy is probably Walt Disney, who filed twice before hitting it big. Now in a bankruptcy, a debtor, which is somebody who owes money to other people or entities, files a document with the bankruptcy court. This document is formally known as a petition, and it asks the federal government for protection against creditors and collectors who would otherwise be hounding them. Now there are four different kinds we're going to talk about. The first is the Chapter 7. That's a liquidation process, or one of the reorganization processes known as Chapters 11, 12, or 13. We'll start with Chapter 7. In Chapter 7, liquidation, a debtor's petition lists all of his assets, his debts, his liabilities, and his income. The government allows the debtor to keep certain belongings known as exempt property. That's property that's protected from creditors and collection actions under the bankruptcy process. Under Texas state law, it could be federal, but under Texas state law, this includes a debtor's homestead property, one car per driver, tools of trade such as welding gear or computers, 401k accounts, you can keep those, any other retirement fund that's so-called qualified, and a host of other belongings. There's another whole set of exemptions under the federal rules, and we choose between those two sets of rules to figure out what's going to serve you best. It's one of the reasons why it's better to have us do it than to just try to do it yourself sometimes. In a petition, the process treats secured debt different from unsecured debt. People always say, what's the difference? An unsecured debt is a debt that nobody can take from you anything if you don't pay. Credit cards, medical bills, the dentist's office is not going to come get a filling that they put in. And those are all unsecured debts. Secured debts are debts where if you don't pay it, you're going to lose something. Usually it's a car or a house. So if it's not a mortgage payment or a car payment, typically for most people, it's going to be secured debt. And credit cards and medical, it's going to be unsecured. Now to Chapter 7, a debtor must pay all of his secured debts and get them all caught up by the end of the process, usually 3 to 4 months. So if you're behind on your house, behind on a car, you're going to lose them. Chapter 7 only gives you a delay. It doesn't solve the problem. It gives you some time to catch up, but not a lot. Now one important question I often get every single time I meet with somebody, they say, do I have to list all of my debts, all of my credit cards, everything that I owe? And the answer is yes. Sometimes people want to say, I've got one credit card I've been good on, and I want to keep that. Well, we have to list it. That's the law. You can try to reaffirm that debt. I'll almost always say, no, let it go. Even if you try to affirm that debt and keep that open, usually the credit card company will close it anyway. So I will always advise you to close it, or usually, but you can try to keep it open if you want. Sometimes people have relationships with the credit union, and they can do that, but usually not. Another question I hear a lot is whether somebody who's struggling in a marriage, should they get a divorce first or a bankruptcy first? You can both file together when you're married, so it's cheaper to file one time, pay one set of filing fees. However, if communication has disintegrated and you're not going to be able to figure things out, you can't talk to each other, you're living apart, that's usually not going to work. You just go ahead and get your divorce finished, finalized, and then start the process of bankruptcy. Bankruptcy court does not want to deal with your divorce. So, cost. Chapter 7 costs about $300. Chapter 13 costs about $300. Chapter 11, now we're bumped up to $1,000. Chapter 11 is very complex. And Chapter 12 is also about $300. Attorney's fees is a lot different, and we'll talk about those. Attorney's fees for what I call a simple Chapter 7 in our office started right around $1,500. It goes up with complexity. If you've got judgments, lawsuits are going on, we're going to have to stop. It'll go up. Chapter 13 is twice that. But some of that can be put into what's called a plan. We'll talk about that in a minute. And not everybody can file a Chapter 7. And Chapter 7 is usually preferable to a Chapter 13 because a Chapter 7 is you do it, you file it, you get it done. 4 to 6 months max, usually. But if you've got what we call over median income, you make more money than the average person in our state for your family size, then there's a means test you have to go through. And that's just a simple calculation which we go through, and it takes your expenses and your income, and it kind of calculates how much money you should have towards a plan if you're going to try to pay off your debtors over a period of time. So if you qualify for the means test and get a Chapter 7, usually that's preferred, unless you're trying to save a house or a car, or you go to the 13. Now there are several differences. Chapter 13, you can put some of the money you're going to pay your attorney in the plan, so there's less money up front. Now there's more money in the plan, so you're paying about twice as much, but you don't notice it because you don't have this big $1,500 payment plus filing fees all at one time. In a Chapter 7, you can't owe me money as your attorney when we file. Now there are several other types of attorney, two other types of bankruptcies we have to go through, Chapter 11 and 12. Chapter 12 is for family fishermen and farmers. Most of my clients aren't of that nature, and you probably aren't, so we'll just say it's a reorganization plan that's similar to a 13. Then there's Chapter 11. Chapter 11 is what an entity has to file if you've got a struggling business, or if you are Donald Trump and you've got a lot of debt, more than $1 million, somewhere in that nature, in that neighborhood, you're going to have to file a Chapter 11 instead of a Chapter 13. Again, 11, 12, and 13 are all reorganization. It's a payment over time based on how much money you have after you pay your expenses. In a Chapter 13 and in a Chapter 11, what we're going to do is we're going to pay all of your arrearage. If you're back on your house, you come to me and you're 6 months back on the house, you're getting ready to get foreclosed on, we're going to file a Chapter 13, probably, and then you're going to get caught up over the period of 3 to 5 years, depending how much money you make and how much debt you have and what we can get done. But you're going to pay all that secured debt back. You're going to try to pay some of your unsecured debt back, your credit cards, if you've got money to pay for it. But what we have to do is pay off all of your secured debts. Now let's talk about the process. You call us, if you watch this video, and maybe you call us and I say, watch the video. You call us back up, you set up an appointment, you come in, we describe this process, we go over some questions you may have had after watching this video, or in case you didn't watch the video, which would be weird since you're watching the video. And then you're going to ask a few questions. I'm going to ask you some questions, and we're going to talk, and we'll probably decide that you either definitely can handle a 7 or go through a 7, or definitely going to require a 13, or we don't know. We're going to put together a contract that'll say we're going to take some money, we're going to give you these forms to fill out, you're going to bring the forms back along with the rest of the money that we decided you're going to pay. We're then going to go through this paperwork. It's going to take you probably 2 to 3 weeks to get the paperwork together. It's not hard, it just takes time. Then we're going to take 2 or 3 weeks to put your petition together. You're going to come in, if you have a spouse, he's going to come in too. You're going to look at the petition page by page. You're going to ask all the questions you want to ask. This is going to be in front of me or my paralegal. Usually it's both. And then we're going to go through all the questions. We're going to make sure you understand everything. And then we're going to file. About a month after you file, well, first of all, the credit card calls stop after about 2 days after you file. Everybody gets notice. And that's one of the big things about a bankruptcy filing is it's something called the automatic stay. It comes in and stops all foreclosures, all repossessions, any option or any effort to try to collect debts from you. It all stops. About a month after that filing, we're going to have what's called a 341 meeting. The 341 meeting is an opportunity for the trustee, that's somebody who works for the court, to look at your case, ask any questions they have. Now, people are always very anxious about this. They're just racking their nerves. It's usually about a 20-minute process. It's just a few questions. It's not a big deal. The trustee is not trying to find out what you did wrong. Visa is not going to show up. Of course, I always say that. Someday they will, but I've never seen them show up yet. About the only people that show up are angry ex-wives or angry ex-business partners that have the opportunity to ask you questions. And you have to answer them under perjury. But it's in a room about the size of my office. There are a few people there, and you have an opportunity to see other people go through it along the way. Then, about a month and a half later, you get a discharge. The discharge means that nobody can come and collect on those debts ever again. That's in a Chapter 7. And in Chapter 13, what it means is it's not a discharge, you get a confirmed plan. And you're already making these monthly plans, monthly plan payments as soon as you file to the trustee, who starts to pay off the arrearage on your secured debt. And you pay that along with your mortgage. So you have to have income in a Chapter 13. You don't have to have income in a Chapter 7. But you have to have some income ongoing that's at least a little predictable in a Chapter 13. And that's pretty much the way it goes. In a Chapter 13, it takes 3 to 5 years, and then you get your discharge. In a Chapter 7, it's done usually 6 months or less. Now, you probably have a few other questions. What about this or what about that? Feel free to holler at us. Make an appointment to come in and chat. Usually we don't charge either anything or, well, I'll just tell you. Mention this video and we won't charge you anything to come in and visit with us. And then you can ask all the questions to your heart's delight. You can visit our website at www.norredlaw.com. Norred Law is NORREDLAW.com. It may be at the bottom of your screen if I've done this right. Our phone number is 817-704-3984. It's 817-704-3984. Feel free to call. We'd love to visit this office, and we can answer all your questions. Thank you and have a good day.